Hello, welcome to a brief summary of the EFLIT class on contracts. Here on the board, you find some of the keywords that we used during the class. Let me go through the list with you. First of all, my best translation for contratto, in fact, is agreement. But contract is, of course, equally good. In every course on contracts, you are taught that agreements have a series of essential elements. And I listed them here for you. You need an offer. The offer must be accepted by the other party. And you need consideration, which is a rather complicated concept, which is somehow similar to price. That is the value exchanged in a contract. Of course, capacity of parties sometimes is relevant, and legal formalities may be required in different jurisdictions for different types of contracts. Here you will find a list of agreements that are common in the world of commercial transactions. Sale agreements, contratti di vendita, lease agreements, contratti di locazione. Careful, there's a difference between agency and distribution, and you can look it up. In banking, loan agreements, contratti di prestito. And of course, in litigation, settlement agreements, which are the agreements to terminate or avoid litigation. Il contratto di transazione. If you are a lawyer or an accountant, the retainer agreement or the fee agreement is the contract between yourself or your firm and your client, where you specify the terms of your relationship and obviously the fees that you expect for your services. Now, Claudia will give us additional tips on the use of these words and a few examples on how to use them effectively.
Thank you, Stefano. I'd like to add another term to Stefano's list, and that is breach of contract. Okay, so a breach of contract can occur if any of the agreed terms of or conditions are broken by either of the parties. Talking about parties, I'd like to mention that in different types of agreements, parties have a different name. For example, here we have a sale agreement, and the two parties are actually called the buyer and the seller. In the case of an agency agreement, the two parties are called the agent and the principal. In the case of a lease, the two parties are called a lessor and a lessee. I'd like to conclude with legal formalities. In Italy and in the UK, real estate contracts must be in writing. That means they need to be in written form. Thank you very much. This was a brief summary of the EFLIT class on contracts, and thank you for watching.